Hello friends, how are you? Today I am going to discuss an important topic concerning section 138 of NI Act. The present class is taken to remove all your confusion concerning check dishonor or check bounce case. So I will discuss the various defense strategies so that whenever you are going to contest a case under section 138 of NI Act, you may consider the said defense perspective and could be succeeded in your case. To be noted that check dishonor is a special offense. So on technical grounds, we could be acquitted. The primary ground is that the check must be drawn by you. And apart from that, the account must be maintained by you. If check is not drawn by you, even though it is a joint account, it is signed by co-drawer. In that scenario, you could not be liable as per law. And apart from that, it is issued out of account not maintained by you, then you could not be liable. And that's why at the inception, the language of legal protocol reads that where any check drawn by a person on an account maintained by him with a banker. So if check is not drawn by you, it is not from an account maintained by you, you would not be liable. So this is the first defense strategical point in your favor. The second point is that it must be towards the discharge of any debt or liability. To be noted that the liability or debt must be legal enforceable. If it is not legally enforceable, in that scenario, you could not be liable. To be noted that there is no presumption of debt. The debt is required to be proved by the concerned complainant beyond reasonable doubt. To stand the debt, he might place on record the corroborating or sustaining evidences. But sometimes there is a plea from complainant that the check is issued by the concerned accused and it contains the sign or signature of the concerned accused. And that's why he would be liable and liable to be convicted. To be noted that in such a scenario, the execution of check cannot be considered to be a valid point in favor of complainant. In that scenario, there is a mere presumption of section 139 of NI Act, and the said presumption can be refuted by putting provable defense on record, by the virtue of which we may stand the probabilities by the virtue of which the case of the concerned complainant could be put under suspicion. For example, Mr. A says that Mr. B inter alia borrowed rupees 1 lakh from me. To pay the same, he has issued the check. It was dishonored, notice is given, and finally case is filed. But Mr. B submitted that out of 1 lakh 50,000 had been paid from bank prior to check bounce, and the said fact is concealed and not endorsed deliberately. In that scenario, by raising the said defense, the debt submitted by Mr. A becomes doubtful. In that scenario, the case would fail as there is no legal enforceable debt, and in the light of probable defense raised by the concerned accused, presumption inter alia refuted, and now the burden is on the complainant to show that why he has not shown or endorsed the said alleged transaction. If he inter alia failed to give an appropriate explanation regarding the same, in that scenario, the check case would fail. So the said scenario is second important defense strategy in our favor. And apart from that, it inter alia bounced or dishonored for the reasons mentioned in the memorandum. To be noted that basically for memorandum we are having statutory presumption as far as section 146 of NI Act is concerned. But if the concerned memorandum does not contain the seal or signature of bank authority, in that scenario it would not be admissible. Apart from that, if it is a bank receipt, and apart from that it is the electronic document, in that scenario it has to be filed as per the protocol of section 63 of Bharatiya Sakshya Adhiniyam or section 65B of Indian Evidence Act. If it is not done, in that scenario, the memorandum would be inadmissible and we could be succeeded. So the memorandum and signature on it would be the third important point of defense strategy to be noted. So we may conclude that if the consent memorandum is not signed and sealed by bank official, or if it is in electronic format and never supported with the help of section 63 of BSA or 65B of Indian Evidence Act, in that scenario the said memorandum would be inadmissible and we could be succeeded in a check bounce case. To be noted that when a check is bounced or dishonored, the cause of action never arises. It arises only when the check is dishonored and notice of that intention is given to the concerned accused, it is duly served, and within 15 days from date of service of notice he failed to make the payment. Only in that scenario the cause of action would arise as per section 142 of NI Act, otherwise it would not arise. So on that point we may have the fourth defense strategy, because I have observed multiple cases wherein the complaint was filed prior to the point of limitation. In that scenario the complaint would be a premature complaint and we could be succeeded. So basically if you are going to consider section 138, we are having four defense strategy on the basis of which we could contest and could win a check bounce case. I hope I am totally able to enlighten you on the important subject. I request all of you, if the content appears to you appropriate and inter alia it enhance your knowledge or information on subject, please subscribe my channel and share this video so that your colleagues, your friends, your concerned loved one could be enlightened and could defend themselves in a false check case. See you in the next video. Till then, Jai Hind, Jai Bharat.